The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. My name is Brandon Griggs, the VP of Education and Professional Development for TECUSPA, and we would like to thank you all for joining us here this afternoon for today's session. Real quick, I just have two quick announcements. The first one is on March 30th, we will have another webinar, Community Through Compliance, supporting our LGBTQIA community on campus. And then also, we have some officer elections for TECUSPA upcoming here in the next month, and so that will take place mid-April. Information about voting and candidates will be available in the upcoming spring TECUSPA newsletter, so feel free to look for that at the end of this month and also on the website. If you have not already renewed your membership, please do so quickly so you can ensure your ability to vote. So during this presentation, if you have questions, please feel free to add them in the chat box to your right throughout the presentation, because it's going to be more a dialogue rather than anything else. So to introduce our speaker, Scott Lewis, as many of you know, he's a co-founder and an advisory board member on ATICSA, NABITA, and SCOPE. Previously, he served as the special advisor to St. Mary's College, an associate vice provost at the University of South Carolina, and worked in the student conduct and residence life areas at Texas A&M University. He also serves as a faculty teaching courses in education, law, political science, and business. He has worked with the Department of Justice's Office of Violence Against Women as a trainer and consultant, and was a consultant to the Office of the Vice President and White House Task Force on issues of sexual misconduct and Title IX. Scott brings over 20 years of experience as a student affairs administrator, faculty member, and consultant in higher education, and we are very happy to have him with us here today. Thank you.
Thanks so much, and I appreciate it. And I'd like to thank everybody for rejoining us after our technical difficulties last time, which you know, are what they are. I kind of blame myself whenever those things happen because of my lack of technical prowess. I mentioned, somebody asked a question earlier, there's a couple of documents that I will forward out to folks after this through Brandon, and so I sort of have a list of things I want us to be sure to cover. I'm hopeful, as was already indicated, that this can be a bit of a dialogue. I want to make sure that you all are giving an hour of your day, and I want to make sure that it's a valuable use of that hour. And as you have questions that are certainly relevant to this topic, which is sort of Title IX, but also if there's some more generalized case law or legal questions that you're facing, be sure to bring those to my attention as well, and I'm happy to answer to the best of my abilities or get the answer back to you as fast as I can. The things that I wanted to address, and we did a version of this last year, sort of a town hall, is like how I kind of think about it. There's sort of the issues that continue to pop up, that continue to provide some challenge for us, and for many of these issues, there are some common practices that most schools engage in, but what I want to make sure is that we are addressing the evolution of those common practices. I do want to give a brief update on some of the political ramifications of this in terms of the bills that are heading out. Obviously, we're going to focus on Title IX, and obviously in Texas, the Guns on Campus bill, like many states, is providing some challenges that are going to perhaps trickle over into areas of conduct and harassment, but probably won't be gender-based as Title IX. But, again, none of these things happen in a vacuum, and so there's always a lot of crossover between gun rights and harassment and free speech and academic freedom, and then conduct and student conduct and employee conduct matters. So my agenda for today really is to touch on a couple of things with the pending legislation, some changes, some things we think are getting some traction, talk a little bit about some of the crossover we're seeing now between free speech issues and how we need to manage those as they relate to Title IX, given a couple of recent decisions. And then the three areas that seem to provide a fair amount of challenge this last year, since last we spoke, that continue to pop up are due process issues, the issue of off-campus jurisdiction over certain matters, and the emerging one, I think, is going to be this appellate process, given two cases that were just, one that got kicked back on an erroneous outcome, and one that just where the school lost the motion for summary judgment. So it's going to proceed now to the next stage, which will probably be settlement but it really centers around a First Amendment and appellate due process issue. So I think these appeals things are really ripe right now, and given the varying levels of folks that are on this call, and I don't have everybody's title, but I'm assuming, given my past membership, that the range is pretty broad from vice presidents on down to sort of entry-level folks and a lot of mid-level folks. So let me start with then, and if there's something else somebody wants to talk about, again, enter it into the chat box. Corey, that's accurate, right? They can just type their messages down in that chat box or down in the question box, and it'll show either to us or to everybody, correct?
Yes, or enter into the questions tab.
Right, so either one of those places would be great for us to get those questions. Currently, there are a couple of interesting things. The McCaskill and Boxer bills continue to be discussed in committee. There's still some movement in those bills. I think the ones that we need to pay close attention to is the issue of the fines. There doesn't seem to be any traction at all that there will be some monetary penalty for failing to comply that'll be a power that'll be new for the Department of Education's Office of Civil Rights. There doesn't seem to be any traction in it staying at $150,000 per offense, but there is some traction in there being Clary-like numbers being bandied about. And there's also a fair amount of discussion about not making that a fine, but instead forcing your institution to earmark that money for prevention or response to gender-based discrimination. And whenever they talk about this stuff, they're always talking about sexual assault. So that may come in the form of staffing or training, but that money will be have to be applied. And we're happy to hear that because it certainly will relieve the burden on folks that are Title IX debt coordinators or deputy coordinators where that got added to your job responsibilities. But because I know where everybody's struggling for funding, but it's going to force the school to perhaps schools that around. I would encourage schools to start keeping track of what kind of monies, staffing patterns. If somebody's got 2 jobs and this is one of them, how much of their time are they spending on that? This is going to be increasingly important as we start getting asked, what kind of resource are we putting toward prevention and response to these issues. The other piece that I think we all need to pay close attention to are these climate surveys. Some of you, or many of you, are already doing this, but I think the emerging area on that is going to be what happens with the data. For the public schools on this, that data will in large part be subject to FOIA requests, Freedom of Information Act requests, and I'm fearful is probably not the right word, but concerned might be the right word. I'm concerned about what might happen with that data if it were put out into the media and slanted in such a way that it would not to damage the campus's reputation as much as I'm concerned that it would be misconstrued and then might have a negative effect on people wanting to do campus survey or climate surveys again or wanting to skew the questions. It could actually defeat the purpose of it. I've had this discussion with some folks in DC, and we're going to keep doing them, and the data will be what it is. But I'll keep pushing on this, and if we hear anything at Atixa, we'll certainly let you know as soon as we can. The other thing to keep in mind as we start to move forward in this is paying very, very close attention to what the trainings that we do on campus for the investigators, for the adjudicators, for the appellate officers, not only tracking what they do, but the topics of those. Was it an internal, was it an external, was it a webinar, what was done, and what competencies were put forward. Keeping track of that is going to save us quite a bit. A case came out of Ohio last year where the judge paid attention to the fact that these folks had been through a 2-day session of training, and the judge really took that as a, hey, look at that, good for them. They have been through this training, so we know that the school's committed to doing these investigations properly. And being able to show what that training was, who did it, what were the competencies covered, is going to be more and more important as we continue to go on. The other bill I want you to pay attention to was proposed late last year. It's still floating in committee. I'm unsure of where it's going to land. It's the HALT Act. It does some really interesting things, but I think the most interesting thing is that it creates a private right of action for individuals when a school fails to meet OCR guidelines. And so in some ways, Spear Meehan mimics McCaskill's and Boxer's, but in other ways, it's I think the biggest change there is that there would be a movement of these guidelines almost into national standards. And I don't know that that's the best thing that can happen, since the guidelines really don't have the weight of law, but once they move into being national standards under this bill, they don't have the weight of law per se, but it would be very law-like, and certainly for state causes of action, breach of contract, negligence, it's going to make those standards even more so. We've already seen a couple of cases where the OCR standards and guidance, we saw at least 2 this year in the document I'll send you, will outline a couple of these cases where the court cited those as sort of the thing we should be doing. So keep that in mind. We're going to continue to see increased reporting of this. We're going to continue to see increased attention to it by the media. There's no seeming indication that this is going away regardless of the outcome of the election, the presidential election that's coming up, although there are those who would argue that, if the certain people, certainly Senator Cruz has indicated that he'll abolish all sorts of government national offices. We've heard that rhetoric before. It never happens. It would be a pretty big stretch to suddenly say I'm going to do away with the whole IRS, or I'm going to do away with the whole Department of Education. I don't think that that's the case. But in regards to these bills regarding sexual assault and violence against women, there doesn't seem to be any indication that party shift will make these go away. There is, this last couple of weeks, there has been a push back against the OCR by some members of the House wanting the OCR, and this will make some of you feel very good, or maybe have a moment of schadenfreude. If you don't know what that is, look it up, where the OCR was called before committee to basically ask why they're not completing their investigations into our campuses in a timely fashion, much as they instruct us to have to complete those investigations in a timely fashion. So a little bit of turnabout is for play, which is good. I think it's fair. So keep those things in mind. That's going to be a big thing. Is just if you are under investigation, if you're not, you probably will at least have an inquiry at some point. More and more people are availing themselves of the OCR, and so don't be too sure that you won't have that knock on your door, and to prepare for that appropriately. And really, it tends to be a bit of a document, not more than anything else, but it's something to pay close attention to. The First Amendment aspects of this, I'm going to shift gears a little bit here, and what we're really seeing here is a collision of a number of seemingly incongruent feelings. There is this notion of, and I'm going to speak for our students to some degree, where the students are saying, I want a safe space where I can never be offended, and people can't say things that make me uncomfortable. And the collision between that and academic freedom, where professors are saying, you know what, this is the place we do talk. And that's not a new collision. It's just interesting how much traction it's gotten. And then you tie that to the conversations about trigger warnings specific to sexual assault and gender and sexual harassment and suicidality, and faculty being asked to give everybody a warning if they're going to talk about anything controversial so that nobody's feelings are hurt. And it's a really interesting sort of juxtaposition when you have these same students who want to go out and protest any number of things, and in those protests often say things that could be considered controversial or offensive to others, and it's really sort of mimicking a bit of this, and I'll wax philosophical for a moment myself, and I'm not speaking for a Tix or Incrum here. This is sort of Scott. I think it's sort of sad, a sad mimicking of what we're starting to see in the political process, where it's I get to say whatever I want, and if you disagree with me, then I will challenge you or try to silence you for offending me, which is sort of a weird way to go about principled debate, which is what's supposed to be happening. So I'm not surprised that some of this media aspect of that has trickled into our classrooms and trickled into our out of classroom spaces on campus, but it's going to continue to be a challenge because the First Amendment is alive and well. For private schools, obviously, you don't technically adhere to the First Amendment, but there's usually a contractual application to it because of all the stuff you put out in your material saying we have a huge, we have a commitment to free speech in the marketplace of ideas, et cetera, et cetera. So keep those things in mind that as these harassment cases continue to come up, we're going to see them trickle over into the First Amendment, crossing over with Title IX. FIRE will continue to write about this repeatedly, and to some degree, I don't agree with everything that FIRE says, but in some places they're right, which is just a reminder. Like I don't agree with the sort of fear rhetoric that every little thing that can be said is suddenly going to be considered sexual harassment, because the guideline and the threshold, I want to remind everybody on this call, for sexual harassment, particularly verbal harassment, is that it needs to be first objectively offensive, and it means which would have to be also unprotected speech, but also it has to be persistent or pervasive. And so those single utterances in class, a couple of things said here and there on a campus versus something that is constantly over and over again in class, or a constant barrage via social media or otherwise, is going to be far more likely to reach that pervasive or persistent threshold than just those few comments. That said, we would do well to help our colleagues to say things like, hey, that may not be a good administrative practice or a good academic or pedagogical practice to say certain things in class that are sexist or sexual in nature, particularly when your class doesn't necessarily lend itself to that. So keep that in mind as we move forward as well.
Hey, Scott, you go through some of your documents. Would you be able to zoom in on some of those so we're able to see them a little bit better on our end?
What are you looking at?
Your PowerPoints.
Oh, those are my note PowerPoints, but those are the ones I'm going to send out.
Oh, okay, perfect.
I didn't know you guys could see my screen.
Yes. No, yeah, that's fine for using those.
Then that document right here to my right, man, I'm glad I didn't have anything else up.
Okay. We were on this end.
I will send those out, actually. I didn't know my screen was up. I'm so sorry.
No, you're fine. You're fine. Thank you.
Yeah, that one document to the left is the one I'm going to forward out. The one to the right was actually just my notes from my case law presentation.
Okay. Sounds good.
You can see my desk. That's my family. Yeah, that notes was off the first one. So the next thing I want to move down to is off-campus jurisdiction. Are you still looking at my screen? I feel uncomfortable now.
Yes, we are still looking at your screen. If you want to put your notes back up, please feel free. That's fine.
Yeah, I'll put this back up. There we go. That'll be better. I was going off these notes to my left here, and I'll just do that. So the one to the right is actually just it's a case I was looking at before the phone call started. It's a little awkward. So yeah, there's a moment for me. So the other thing I want to talk about, though, is this issue of off-campus jurisdiction. And actually, this case, it's not in this notes, but I'll send you the long version of the cases so you can have this. But it came up in about 3 or 4 cases, one in Virginia, one in California, and I want to say somewhere in the middle of the country was either Nebraska or Kansas or Iowa, one of those 3. But the question that came up really centered around the notion of when should campuses assert off-campus jurisdiction. And the idea that we have to assert off-campus jurisdiction over sexual assault and high-end harassment, because the impact of that obviously trickles back onto our campus, is something that everybody needs to keep in mind. And so the notion that we would not assert off-campus jurisdiction over certain things seems to be going by the wayside in the sense that, yeah, I thought it was on here, but it's not. It seems to be going by the wayside in that we know there are far more other behaviors that we do assert off-campus jurisdiction over, and we want to make sure, for those of us who have either employee control over the employee manual or control over our student code of conduct, it's going to behoove us to do something we've not historically done, which is to actually take a look at our conduct code and, in at the very least, an internal document, make the statement of what things we will assert off-campus jurisdiction over and won't. Most conduct codes, not all, but most, on the student side, make some statement about the fact that if that it's a behavior that might impact the safety of the campus or disrupt the mission of the campus, that we reserve the right to take off-campus jurisdiction. But I think conduct officers would do well, and deans of students would do well, to be a little more specific. And we might even go so far as to say that's our generalized statement, but internally we have a list of things we will and will not assert off-campus jurisdiction over. For example, minor non-felony possession of drugs. So somebody has a little bit of marijuana, they get a ticket, we're not going to assert jurisdiction over that. One that might be a little more controversial would be DUI. Do we want to assert jurisdiction over that? If we learn that a student, and again, we don't have to go looking for this, but if we learn that a student has off-campus, has got a DUI, do we want to assert jurisdiction over that or not? And the reason I say it would do well for us to have this list of things that says this is what we will do, this is what we won't do, then you would want to have that list out there so that later, if questioned, why did you assert jurisdiction over this person's DUI but not that person's DUI? One, you'd either say, oh, we asserted over all of them, we didn't learn about that one. You'd have some reason, and you won't have to answer the uncomfortable question, which is that basis for which you took some jurisdiction over some things and not others, is that centered around some protected class, male, female, gender, race, ethnicity, national origin? Is there some other protected class reason you might have done that? And so that list is going to be helpful. Again, I think DUI will be a relatively controversial one. Social media in this last year, the cases that popped up about that will also be in the document. I'll forward it out to you later. It's a long document. It's our case law review. There's a couple cases in there in the First Amendment section that talk about campus, the courts now recognizing that things that happen in off-campus social media have an impact onto our campus. Particularly with this issue of cyberbullying, cyber stalking, harassment that takes place off campus on Facebook or Snapchat or whatever. Paying close attention to that as we go forward is gonna do us well. If there are other things you don't want to assert jurisdiction over, that might be a shorter list. But I would be pretty clear in that internal document. Again, I would hesitate to put all of it in our policy just because changing policies is very, very difficult. But in an internal document, I would definitely put it up there in terms of here's the things we'll take, here's the things we won't. I think for the purposes of Title IX, you would probably serve yourself well to say that if it's any violent act and any stalking act, you're definitely going to take it. Bullying, probably. But some of the lower end verbal harassment that might happen off campus, unless it has absolutely trickled onto the campus, I don't know that we want to assert jurisdiction of that. The example being two people have a job, they both work somewhere off campus, they're commuter students, and at work they're harassing each other at work, or one of them is harassing the other verbally at their off-campus job, and then they both go to our school, but they're not in the same program. That might or might not be true. If they're both in our school and they're both in a cohort nursing program or teaching program or something like that, obviously that could be a different trickle there, and the harassment would inevitably have trickled onto our campus anyway. So making that list internally is going to serve you well in the long run for both protected class questions as well as just really institutional consistency and a bit of sense of fairness to the students, so they can have a sense of why we're doing these things and how we're doing these things. The next piece I want to shift gears and discuss. Anybody have any questions about the off-campus jurisdiction or the First Amendment stuff or any of the pending legislation? Nothing? Okay. Then I'm going to shift over to the next topic, which is due process. And these next two topics really sort of go hand in hand in that's due process and the appellate process. And I'm going to start with due process because the claims, I mean, one of the fastest pieces, things that are coming up is the challenges to us by the folks who've been accused and found responsible of sexual misconduct, most commonly sexual assault, but now we're starting to see it in other areas, including just harassment. Those challenges come in two forms. One, it's a challenge to the quality of our investigation and or hearing. And for those of us whose hearings are really sort of secondary investigations, I would encourage you to stop doing that. But the reality is the challenges will continue to come on the quality of those. And when that happens, you know, they need to look at the due process side as well as what they call an erroneous outcome. There was just one that came out of Cornell today where the court looked at it as an erroneous outcome, which means there's no way that there's no way they could have found what they found given the information that was there. Those erroneous outcome claims are really difficult because it's really the court almost second guessing our process and our adjudicators, which they usually don't like to do, but can. So be mindful of that as well. The other part about the due process, though, is this notion of the fairness of our processes. And so paying very close attention to when we put individuals on notice that the investigation is underway, being transparent about what that investigation looks like, our process and who we're talking to, and when we make a decision to interview someone or not interview someone, that we're clear with the parties as to why we're making that determination. They don't have to agree with us, they just have to understand why we're doing it. We need to have a rationale, and that rationale needs to be explained as we're going through. And you can see how this sort of ties into the investigatory side of this challenge. So sloppy investigation, sloppy adjudication equals unfair process, but we also need to take a look at our process and make sure it is not fundamentally flawed. If we have panels making determinations or an administrator making determinations, and that administrator comes from a pool of people who can make those determinations, how is that pool selected? Who trains them? Who makes the determination as to who will sit on the panel to make the decision or not? And it can start to look more and more as we receive more and more scrutiny like the fix is in. If the person is I'll give you an example from one of the cases. So I'm the investigator, and I work very closely with the Deputy Title IX Coordinator, excuse me, and at the end of my investigation, my process requires that I make a finding. And by finding, I mean not just a finding of fact, but a determination. So I decide at the end of my investigation, my report says, and this is why I think the party violated this policy and this policy and this policy, but not this policy. And then the party goes to a hearing on this matter, and that hearing panel is comprised of, let's just say, faculty and staff, and they're going to get to see my report with my determinations at the end of those report. And wait, I get to pick who those panelists are. Now, most of us on this call know, if you've ever tried to schedule a panel hearing for anything from academic integrity to faculty misconduct to student misconduct, really, if you're coming from a pool of panelists, the most difficult part of this is just the scheduling. Trying to find a time when people are actually available is harder than anything else. And so in the process of selecting that group, there's really no way you could have, I mean, there's not no way, but the likelihood of an administrator sort of putting the fix in and picking the panelists that I want and nobody else is pretty low. That said, when you're on the outside looking in and you're being held responsible, it begins to look like, wait a second, so this guy investigated me. He thinks I did it. He tells me I have a choice of going before these administrators, and I'm going to go before these administrators, but they're going to get to see his report where he says he thinks I did it. Oh, and wait for it, he gets to pick the administrators. And I only have a say in so much as I can challenge them if I think they have bias. And I think that that's going to be a continuing challenge for us, and I would ask that if you are still doing those panels from a pool, that you have somebody else maybe make that pool selection. I would make the argument you would probably be well served to have somebody who chairs that pool of people or some coordinator within that pool of people, and you say, well, here's a hearing, here's the person, all right, here's the people involved. You hand that to that person who's a member of that pool of panelists and say, we want to have the hearing on this date. You pick the people who are going to be on it. And that just gives you, as the deputy coordinator or investigator, sort of a one-step removal. So when the scrutiny comes in about bias or the fix was in, it's there. And this is certainly not what I'm telling you, not any law or anything, but I think, and reasonable minds will differ on this. Let me be very clear about that. I think there's also something to be said for when you're the investigator and you put in there, this is what I think happened, that finding of fact. So I think sex occurred, let's say, is very different than I think policies were violated. And if at the end you have that statement, and I know there can be just a semantical argument to this, that if you read the report, even if I took the part out of my report that says, and for this reason I believe this policy was violated and this policy was violated and this one was not violated, if I took those words out, you might be able to, as a panelist, ascertain that from my statements on credibility, from my statements on assessment of evidence, on the strength. But I still think there's a difference when it's written right there, in particular when I maybe am also the primary trainer of said panel. There's just a lot of challenges there, and from the outside looking in, it doesn't look as clean as it could. And so the cleaner we can make this look, the better off we're going to be, and that really goes from soup to nuts, like all the way through. The other area of due process that is going to be a continuing challenge, we're starting to see the rearing of the ugly head of the challenge for bias of investigators, and this is going to prove a particular challenge to, I think, smaller campuses who have less staff, and well, let's be honest, larger campuses that have less staff, where the chief conduct officer or chief human resources disciplinary officer or chief human resources officer, who is also the disciplinary officer, is then handed a case to investigate because they happen to also be the deputy Title IX coordinator. They're handed that case to investigate, and in the course of investigating it, they, what's the nicest way with this? They at one point also disciplined this person. And so let's just give this life. So, you know, Sammy the student was, or Sam the student is being accused of violating some Title IX based policy. And Sam is being accused by Jordan. And so the discipline officer, at one point, for the purposes of this, let's say a year ago, disciplined Sam for violating the academic integrity standards or drinking underage or something relatively low end, but for which the crux of the claim came down to Sam said he didn't cheat, the disciplinary officer did not believe Sam, so Sam was disciplined by me, Scott. I'll be the dean in this case, or the deputy Title IX coordinator. Now Sam's accused of sexual assault, harassment, whatever, and particularly in the assault cases where credibility is going to be a major factor, I'm assigned to investigate this. Sam's going to have a very fair claim of, wait a second, this guy who didn't believe me 1 year ago is now assigned to investigate me on this much more serious offense, arguably, and I'm going in with the credibility being out of the gate. This guy's got bias, he can't do it. And so for single shop conduct offices who also are charged with doing these Title IX investigations, I think we're all going to be fast moving to a world where either we have a pool of investigators that we can pull from for this purpose, smaller campuses that have maybe consortiums and they're in the same area, you know, like if you're all in the Dallas-Fort Worth Metro and you can share investigators, if that's some sort of agreement, you know, obviously it'd be a little bit easier for like the community college districts up there. But the other way internally to get around that is going to be if you don't have the pool of investigators, but you have what we at ATICSA sort of recommend, which is at the very least several deputy Title IX coordinators, one in academic affairs, one in HR, one in student affairs, one in athletics, that in that case, Scott, the dean of students, now challenged by Sam the student, could say, you know what, I'm not going to investigate it because we do have that history, so I'm going to hand this over to Kim, who is in charge of HR, and she would normally do the employee ones, but here she gets this case because I'm biased out on it. And so that pool model or that shared model is going to be important. And it goes back to something we've all been saying since the tragedies at Virginia Tech 10 years ago, which is we got to break down these silos. We got to break down these walls. We've got to trust people to work with us and work together and manage effectively these investigations, even when it seems like it might be arguably out of their wheelhouse. The only exception I will make to this, what I just said, is that the person who is your deputy coordinator in athletics should, and I say this again, no law, no guidance, this is just Scott's advice, should never be the athletics compliant officer when it involves athletes. There's just no good that can come from that. And notice I did say the word lead investigator. I think there might be some value to your deputy Title IX coordinator in athletics working alongside the investigators if it involves student athletes, just because they'll be able to speak to the culture, they'll be able to speak to the schedules and how things work, and when people share weight room time and practice time and courts and pools and things like that. So be very, very aware that that can be a shared, they can be a partner, but just never should lead that in any way. Just from the outside looking in, it looks awful. And then this is where I'm going to shift over for a minute in the second part, and it's not really due process, because technically speaking in the law, due process is just notice and an opportunity to be heard, but we've sort of added this appellate mechanism to it. And so we recently saw a case, and this is the one I referenced earlier, where the school just lost its motion for summary judgment, and so the case is going to proceed. And for those of you who are unfamiliar with the procedural aspects of the way cases work, let me give you a 2-minute primer on it. So basically what happens is plaintiff sues defendant. And when the plaintiff sues the defendant usually instantly files a motion for dismissal. And there's rules for this, Rule 12, and state have different rules for state court stuff, but suffice it to say, the motion to dismiss is filed. When a case gets thrown out on a motion to dismiss, there's been very little discovery, the sharing of documents and depositions and stuff. There's virtually none has occurred at that point. But the court looks at it very favorably for the plaintiff. They want to say, you know, is there anything here that seems like it would go on? And it's much like you do your investigations. When a complainant comes in and says, this person harassed me, you take a look at it right out of the gate and say, gosh, what you just described to me isn't harassment. So no, I'm going to assume everything you said is true, that the professor called you, baby, or made a sexist reference in class or whatever, but that single utterance isn't it. Bad practice in class? Sure. Against our rules? No. And so you actually sort of dismiss it much like a judge does in this motion for dismissal. If it gets past the motion for dismissal, there is a little bit of wrangling back and forth between the parties, and then it comes up to summary judgment. And for you lawyers on the call, I know I'm grossly oversimplifying this, and my apologies, but it warrants everybody understanding how it works in case you end up on the receiving end of a lawsuit. The next stage is summary judgment, and that's where there's a little more information out there for the judge to consider. And again, this is filed by the defendant that says, hey, even if everything they say is true, you have to look at it, and the words that are often used is in the light most favorable to the plaintiff. But there's a little more back and forth now. There's a little more gutting out of the story. And a lot of cases end at summary judgment. If you look at the document I'll forward to you all later, there's a fair number of them that die on summary judgment. The school wins, but the judge still chooses to opine on the due process. And this one case out of Virginia had survived the motion for dismissal and was actually up for summary judgment, and just this week the motion for summary judgment was dismissed. And it centers on a couple of things. There's a free speech element to it, but there's a due process element to it as well. But I think one of the lessons that comes from it is this notion of appeals. In both cases, the appellate officer, following procedure, or at least the procedure was silent, at least on part of this, but following the procedure, made the determination, and quick fact pattern. So this guy's found responsible of harassment. Found not responsible, it's important, found not responsible of harassing this woman. And in the course of being found not responsible by this panel, there's 4 allegations. They find him not responsible at all. He writes his appeal. The appeal goes up, and the appellate officer confirms 2 of the findings, but overturns, if you will, the other 2 findings, and then renders a sanction of expulsion. And there was no opportunity for the responding party to um, give documents or have a oral argument or anything at all, and the court makes a note of this, that gosh, this guy who you now overturned and then removed from school on a permanent basis had no opportunity to comment on this appeal. And this is not the first case like this we've seen, but it really continues this door that was tacked open a couple years back continues to be pushed wider and wider open, and we've really got to clean up our appellate procedures. Now, under Title IX, we know that if we offer an appeal for one party, we have to offer an appeal for the other party. We know that under Clary and VAWA, we're expected to have our appellate officers trained, which is a bit of a challenge for some of our presidents and our provosts and other upper-level administrators who serve in these appellate roles, sometimes formal, sometimes informal, but also don't have any training on how to do an appeal. And so there's some things that we just have to do, and I've talked about this before, but these cases continue to bring it to light. And one of the things that I think might have cleaned this up, if your appellate procedures were silent on the procedure, is one, the remembering that when somebody does have an appeal, particularly even if you use a civil rights model, it's the one place in an investigation in the civil rights model, for example, there's no burden of proof. There's a standard of evidence. Either the evidence meets the standard of preponderance or it doesn't. And so the investigator is looking for just putting things on the scale and see how it goes. Once there's an appeal, however, the party, and this should be written into your policies, does have a burden. The appealing party needs to have a burden to show error. And in our model policies, we've talked about grounds for appeals and what those grounds should look like. And inherent and implicit in the statement I just made is that these folks that are appealing aren't just appealing, but in fact they're requesting that their appeal be heard. And that's another element that most procedures don't have and should. You want to have this element where the party has to ask for the appeal to be heard, not just this default position that because I think there's new evidence or because I think there was a procedural error, it's automatically considered as an appeal. Because that doesn't happen in other adjudication systems. There's either an automatic review in other systems or there's a request for appeal. And even in the courts, you're going to the U.S. Supreme Court, there's a writ of certiorari that you ask the court to hear the case, and in most cases they don't. The person reading that request or the appellate officers also should exercise a fair amount of deference to whoever heard the case first. And I think that's the first thing that the court in this particular case out of Virginia looked at was to say, wait a second, wow, this person was found not responsible by people that considered all the evidence after what the school says was a thorough investigation. No, not responsible, not responsible, not responsible, not responsible. And then this appellate officer, in just reviewing this one side of the appeal and then looking at some of the documentation, says, you know what, responsible and responsible. And the court says that because they're like, that's not how they normally work. So they have to look to what they are familiar with. And so, again, that deference to the original body should be built in. When there is some error, and I think this is the second lesson from this particular case, and frankly from others, this is not like I said, not the first one. This lesson that if there is error, and that error is determined to be so significant that it would have impacted the outcome, a changing of the finding in this case, and or a changing of sanction, rather than the appellate officer just making that change and saying, nope, we're just going to make the change because of that, it's probably wiser to send that back down to whoever the original body was to say, hey, this sanction doesn't match up with this offense. You stepped outside of the guidance you were given, or after my consideration, I want you to reconsider these two findings because I believe they're in error and should have been found responsible for the following reasons. And that forces the first body, that original panel or original administrator, to reconsider for those reasons and then make that finding appropriately and or fix that sanction. It's when you just do it on your own and kind of swing out there that there's going to be some consideration and a fair number of questions asked by really everybody. You're sort of picking your plaintiff at that point. The other part about that sanctioning piece, when the appeal is on the basis of the sanctions, the higher up the food chain you go, the more potential for politic to begin to play a role in this. And what I mean is whether it's fear of lawsuit from the reporting party, fear of lawsuit from the responding party, because now they're showing up with their lawyer and their mom and their dad and whoever else, their partners, or the status of this individual or their family, whether it's honors college, national merit scholars, star athletes, they have some status, donor or legacy student, that there's more opportunity for that to start to eke into the decision making, particularly when the sanctions involve removal for some period of time. And so I would caution appellate officers to, rather than just make a wholehearted change, to send it back down, number one, and to number two, recognize that when the original hearing body had the opportunity to stay within a certain range of sanctions, if they stayed within that range of sanctions, then they stayed within that range of sanctions. And to alter that on the basis of, I think this is better, the rationale needs to be pretty significant. So if you are going to make a change and not send it back down, or if you're going to send it back down for reconsideration, you should be able to articulate clearly what that consideration is, and it needs to go beyond, I just think this is too hard. Because oftentimes our students will appeal on the basis of, I think these sanctions are too hard, and we just say that's too bad. And so when we say, oh, these are too hard, the outside looking in world, rightfully and skeptically, will take a look and ask the question, gosh, well, what made this person so special? And if they do happen to belong to one of those special categories like honors or merit or legacy or donor's child or politically connected individual or athlete, that's going to be the default assumption. And so we need to be really, really careful when we do that. And the shorthand version of this would be, if the original hearing group was given parameters to operate within that say something along the lines of, it can be suspension for 1 semester up to suspension for 5 semesters, and they went with 5 semesters, or they went with 1 semester, and the appellate officer goes, man, I probably would have gone the opposite way. Well, that's too bad. They had that opportunity, they had that choice, and they opted for the heavier or the lighter, and they made that call. And so you're actually better protected as an appellate officer not changing that, but instead just saying, hey, the group that considered all the evidence that was relevant, the group that we've trained to do this, made this decision. And so while you may not like it, while I may think, gosh, I wish I could have lightened it up for you, that's too bad. And so we need to make sure we're offering appropriate deference and paying close attention to these practices, because they're going to continue to be challenged, and frankly the courts are getting more and more interested in our decision making and making us defend it. The warning shot across the bow from the administrative enforcement of this was when the Office of Civil Rights instructed us that from now on, whenever we make a decision, we have to express the rationale for that decision. So we've gotten that warning now twice, once from the OCR, once from the courts. We will do well to heed it, lest it find its way to Congress, which would be the death knell for many of us, because then they'll start legislating, or God help us, passing an actual law that tells us how to do our appeals processes, which would not be beneficial for us and the cultures we're in. And for your faculty would definitely have an impact, as your faculty processes will be next, if not first up on the chopping block. So I'm gonna stop there. We've been going about 52 minutes here, and open it up to any thoughts, concerns, questions. What's out there? The silence. Corey, Brandon?
Oh, yep. So far, there have been no questions, only really questions about the slides. So if there are questions, feel free to enter those in the chat box or into the questions box on the GoToWebinar panel, and we will share those. And Brandon, you are now unmuted as well.
All right.
First question, do you have any recommendations on good training models for hearing panels from the University of Houston?
You know, there's some free stuff out. I mean, obviously, I'm a partner with NCRM and I'm a founder of Atixa, so I'm going to favor our models. But there is other stuff out there. The NCRM group has some stuff. There's some free resource on the Atixa page about competencies. There's also ASCA put some stuff out for JBoard models. In large part, we contributed to some of that as well. The other thing I would look at is I really like what Chris Lachavo did out at the University of Florida. I think there's some good training out from that if you're looking at training models for JBoards. For appellate officers, there's remarkably little out there, honestly. It keeps coming up every year. To my knowledge, we're really the only ones that do that. There is a fair amount of stuff you can do internally, and when you're looking at a list of competencies, I would really look at, and you know, this probably isn't a good business model for me, but I would really look at what are the things that I can accomplish internally. You know, luckily for us, we work at institutions of higher education, so there are on-campus people who have some expertise in these areas. So understanding, you know, victim and trauma, you know, you could probably have somebody in your community, somebody from your psychology department, somebody from your counseling center. If you have a victims advocate or prevention specialist, they'll probably know how to talk about that. You have lawyers in the community who can come and talk to you about different aspects of the criminal law. You have lawyers in your campus. If you have in-house counsel who could probably speak to that. You know, many of you have areas that you've done research in, whether it's the crossover of disability as trauma and victimology or being accused and what it's like to be innocent and accused of something. You know, you may have a specialty there that you could present on to these groups. But look to see what's internal. My best advice, though, would be sure that you list out what the competencies are. And those competencies are in the materials that we send you, as well as available on the websites. And so you can kind of see that competency-based model that'll be out there. I think it's weird when people are looking at us from the outside, and I know I keep saying that, but that's who holds us accountable. It's weird for them to look at an academic institution where everything is built on degree plans and curriculum and syllabi, and in this very, very important area where academic and professional careers can end, we don't have a degree plan or a curriculum or a syllabi for the training of the people that make these very important decisions. It's one of the reasons I moved toward JBoard training curricula way, way, way back in the day. It's one of the reasons we really promoted it at Atixa with this competency-based model of here's a curriculum, meet these standards, and that'll serve you well.
We have about 4 more questions, the first of which comes from SFA, so great question. How do you explain due process versus appeal to stakeholders and the notion of standard of evidence versus burden of proof?
Okay, the first part of the question, read that first part again, please.
How do you explain due process versus appeal to stakeholders?
Well, most stakeholders only understand, when they hear due process, they tend to think there's a lot more to it. And when I explain it to campuses, whether it's faculty, staff, or students, I remind them that, you know, constitutional due process, first there has to be the removal of a property right for it to kick in. Secondly, that it only requires notice and an opportunity to be heard. There is no due process right in an administrative hearing for some sort of formal court hearing like we have. We created that. There was a last year's white paper that Atixa put out addresses that issue pretty thoroughly. The appellate process, everybody assumes that that's part of the appeals, and I don't know that I would bother getting into a large discussion about whether appeals are in constitutional due process or not with campus stakeholders unless they brought it up. But the fact of the matter is, we created it. We gave them an appeal right, so we're going to have an appeal right. In cleaning that up, I would spend more time on what are the models out there and how can this be done fairly and in a way that serves everyone and isn't just really I don't like the decision you made, so I don't like what Mom said, so I'm gonna go ask Dad, because that's what it starts doing. Or like the Walmart theory of I'm just gonna take it to the store manager. I don't like what this person said, so I'll keep going up the food chain. And those aren't really appeals as much as just complaints. The second part of the question was about, go ahead.
Standard of evidence versus burden of proof.
Standard of evidence is the preponderance. That's the standard we reach. And when we talk about that with stakeholders, I remind them that our investigators are impartial. We don't have a stake in this. We don't care how it ends. So we collect the evidence, and then we see, did it meet the standard of preponderance or not? But when you get into an appeal, you're actually saying something went wrong. So you have to show that something went wrong, and you're making that claim as an individual. It's why sort of the institution does the investigation. It's not, you know, Sam versus Jordan as much as it's Sam has filed a complaint or Jordan's filed a complaint against Sam, and now the institution impartially looks at it and collects evidence. And that's generally how I explain it. It's when somebody's now complaining about that outcome to say that was done poorly, they have to prove that it was done poorly. What's the next question?
What if your appeal pool and your hearing pool are different groups? Do you still suggest the appeal go back down to the original body?
Yes. And usually the appeals people are different. That's not always the greatest model, but it's what happens more often than not. And so if that appeal group has considered that, then it should go back down. The problem that we run into is these appeals groups are rehearing the whole case, and that's not what appeals really are. Appeals are on a specific error and only consider that error. The original body heard the whole case. That ship has sailed. And so, yeah, the appeal body should send it back down. You know, if courts had the ability to reconvene juries when there's an appeal error on the basis of a jury decision, they totally would do it. But they just can't because you already served your jury, do it, and you're dismissed. So it's hard for them to understand why we don't do that when we do have that luxury.
Okay, next question. Can you discuss any guidance on the issuance of no contact orders? Should we always issue to both parties by default? Are there concerns with doing that? And can you foresee a time where we wouldn't want to issue a mutual no contact order?
Yeah, no contact orders should only, in my opinion, the default position is that they should be issued upon request. When we issue them by default without the parties asking for that, it begins to be a little heavy-handed and can be considered an adverse act because maybe the complainant doesn't want to have a no contact order, but now we've restricted their movement, and that could arguably be considered retaliatory. Once those are requested, then we would issue them and issue the mutuality of it. Now, there are people even in the ethics advisory board that would say that for the complaining party, you would have a more limited no contact order than you would for the responding party. But again, that's reasonable minds differ on that as well. The way we might not issue a no contact order is remember that a no contact order carries with it the penalty of failure to comply. And so if somebody does contact somebody, complainant or respondent, they could be considered in violation of policy. And so a reason we might not issue one is if they don't want one or if they're able to have no contact without us telling them that. And so a lot of times the party comes in and says, I don't want to talk to this person, and then the responding party comes in and says, I don't want to talk to that person either. So I don't need to issue a no contact order. They're not going to talk to each other anyway, and I can just ask nicely, and they'll do it. Once we start issuing no contact orders, I feel like those, there's a reason temporary restraining orders require some cause, and so I want that cause to be for our no contact orders. We shouldn't issue them lightly, and so I don't like the idea of just, oh, here's a complaint, no contact order automatically goes out. Let's wait till people ask for it, and then make sure that we actually need it.
Okay, our last question is, do you have any recommendations for the internal list of off-campus jurisdiction?
Recommendations for the internal lists?
Yes, so what types of violations that occur off-campus would you see?
The stuff I would definitely assert jurisdiction over would be anything that has to do with violence, where we have the responding, obviously the responding parties who we have jurisdiction over, so that's the more important one. Anything that has to do with violence, any felony, so felony possession, felony distribution, felony weapons. I would make the argument for weapons, arson, felony larceny or felony burglary, not low-end stuff. I will say, in the interest of full disclosure, I was pretty broad with my off-campus jurisdiction because I found it was helpful for town-ground relations. So if students lived off campus and they lived next to a neighbor and they were tearing up the property or trashing it after parties and stuff like that, and the neighbor had said, hey, can you not do this? And they continued to do it, and they were leaving trash everywhere. I could have that conversation with them. Arguably it's damage to property when they do that, and so I would assert jurisdiction over that. I'm a little broader than most would be. Most people would not like to assert that jurisdiction. I had a rationale behind it. So that's the stuff. Obviously, anything sexual in nature, intimate partner violence, all those acts of violence are going to be there. I'm trying to think of the other one. I was a person who thought DUI should be on that list. If I became aware of a DUI, I want to be able to address it because that's and really for the educational piece of that more than anything else. That's a serious thing that has a real impact on a student and their finances and their ability to go to class. And so I wanted to make sure we were able to not just hold them accountable for the DUI. It's probably a pretty bad world for them already, but also to be able to make sure we're addressing the underlying conduct on that DUI.
Okay, thank you very much. Brandon, you're up.
All right, thank you all for joining us, and a copy of this will be posted within the Tecuspa website, and we will see y'all next time. Thank you, Scott.
Thanks, everybody. And also, if anybody had questions they weren't comfortable asking, my email address is available. Just drop me an email, and I'll be happy to respond as soon as I can. Thanks so much, everybody. Thanks for inviting me, Brandon.
Thank you.